Hello again, and welcome everybody back to another podcast episode of Divorce Well in Florida. I am Matthew Waring. I'm here with my partner today, Brian Dunmire, and together we are Fairway Law Group. We are a Florida family law firm specializing in divorce cases, but we do take some other cases as well. We've got two offices. We've got one in Orlando. We've got one in South Florida. We handle pretty much the whole state, not the panhandle. We do everything remotely. Unless we have to appear in court in person, we cap the travel time at 30 minutes each way. So if you're somebody that is in need of family law services in the state of Florida, you can reach out to Fairway Law Group. We offer 15-minute free consultations. They're easy to schedule. Call our number, get scheduled. You'll speak with Brian or I. We'll go over your case, give you some specific insights, and you can determine what to do next, whether to hire us or not. We'll quote your retainer and you can get started. Today, we're talking about prenuptial agreements. Whether we like them, whether we don't like them, who they're for, who they're not for, what are they? Should you get one? Should you avoid it? And we'll cover some of those things. The first thing that I'd like to say about prenups is that they're not romantic at all. If you want to absolutely kill any romance, love, feelings of affection at all between you and the person that you're marrying, by all means, both of you should hire lawyers, disclose all of your finances prior to getting married, and then engage in a very hefty negotiation over the terms of your divorce. I say that somewhat tongue-in-cheek, but it's the reality. Prenups are not fun. They're not romantic. They're not something that you do casually. It requires a detailed negotiation up front. I think that there is a time and place for prenups, and we'll talk about that a little bit down the road. But for your average couple, juice is probably not worth the squeeze. How do you feel about them, Brian?
Yeah, I agree. I agree with everything, but I suppose there are situations that warrant a prenup, and there are prenups out there, and they can come in handy from time to time. I'll start off by just making a little bit of joke. As a divorce attorney, everybody always has a question, right? Hey, my daughter's doing this, or I'm thinking about this. Should I get a prenup? What are your thoughts on prenups? Or my girlfriend and I are getting serious. I'm thinking about getting a prenup. What are your thoughts? And I always ask, well, do you have assets? And it's just like, no, I don't have any assets. It's like, well, then you don't really need a prenup. If you don't own anything, you don't need a prenup. I'm sorry, this might be a little bit, uncouth or too direct, but like, it's not cool to have a prenup. It's not uncool to have a prenup either. It's essentially a business document, right? It's a transactional business document, but there's no benefit to having a prenup if you don't have any assets. Very general statement there, but yes, I tend to agree. Jokes aside, there certainly are situations where you should have a prenup or it might be worth considering a prenup. And in today's day and age, there are people out there who kind of treat marriage a little bit more like a business relationship, which I certainly respect. And that could be, a good couple for a prenup.
Specifically, who I think is a good candidate for a prenup, people that are older, that are getting married for the second or third time. They both might have had previous families. All their kids are adults. They might have their own retirement accounts. They might own properties prior to getting married. What the prenups do in those situations is they actually protect each person's kids of the marriage, the kids from the prior marriages. Because a lot of times what happens is two people get married later in life. They each have their own kids. These two people might have accumulated some significant assets over their lifetime. When these two older people get married, their kids can oftentimes get at odds about, well, what's going to happen to mom's money? What's going to happen to dad's money? What happens if mom dies first? What's the new husband going to do with her money, with her property? And it kind of creates those situations. So prenups can kind of factor into estate planning a little bit in that respect. It can help kind of draw lines what happens with certain types of property or certain types of financial assets as a result of a divorce or in a marriage. So those type of people, it might be good for. Prenups might also be good for people as well that own property, like physical property with other joint owners, and they want to protect the other joint owners from a fallout and litigation if you get married and then get divorced. The general rule is going to be, if you own property prior to marriage, that's going to be a non-marital property. So even if you get divorced, it doesn't mean that your spouse gets to take any portion or any value out of a tangible property that you owned prior to the marriage. However, your spouse over the duration of the marriage might be able to claim that they're entitled to appreciation in the value of a property. That's a very difficult argument to make. It doesn't always work. But if you jointly own that property with two other individuals, maybe your parents and you are all on the deed to a premarital property. Let's say you and two other members of your family bought a farm. The three of you own that farm and you get married. During the marriage, you and the two other family members that own the farm decide that they're going to build a house on it or a barn or something like that. That adds value to the land. That value was added during the marriage. Even though it was a non-marital property because it was purchased before the marriage, your spouse without a prenup might be entitled to some appreciation in the value of that property. So then in the divorce, your spouse might insist on getting a portion of the value from that property. If you don't have the sufficient cash to buy your spouse out of that appreciation and value for your 1/3 of the property, and it sounds very complicated, but they might join the other two members of your family that co-own this property to the divorce case and sue all three of you to partition the property for them to be able to extract their appreciation and value from your 1/3 of the property. So in that instance, a prenup might be helpful because you can protect those other people from litigation. But outside some of those very limited circumstances, it's probably not necessary for most folks out there.
Going on what Matt said, the way that I would envision a prenup agreement, when it might be helpful to have one, is when there is specific property that you have prior to a marriage. I think that if your intent is, I'm going to graduate medical school and make $500,000 a year, and I don't want my husband or my wife to get any of my money or anything that I buy with my money, you're probably not going to end up with a valid prenup. Maybe it's possible to draft that somehow, but that's a little bit of a far reach. But on the flip side, let's say that you're 30 years old and you own two rental properties that you rent out. You've had them for like 5 years and you start dating somebody and you decide that you want to get married. Certainly never think that I want to get divorced, but if I do get divorced, I just want to be very clear that these rental properties are not going to go into the divorce. Maybe you own them with somebody under an LLC or something like that. Like that specific piece of property would absolutely be grounds for a prenup agreement. Hey, I own this property in Tampa. Here's the address, legal description, whatever. Party fully agrees that this is never going to become marital property. It's not going to be marital property. The value of it, the appreciation of it's not going to be marital property. Same thing if your parents pass away and you have an inheritance or something along those lines. Generally speaking, that's not going to be marital property anyways, unless it's commingled. But if you really want to go belt and suspenders because you have a $2 million trust, you could do a prenup saying the trust in the name of Brian Dunmire as a beneficiary is absolutely not marital property and listed out and comply with everything. One thing to know about prenups, if you're going into a prenup thinking you're going to pull one over on your future spouse, personally, you probably shouldn't. You should probably reconsider getting married. It's not going to work that way. There has to be a full and complete disclosure of the finances of both parties. And then if it's ever challenged, you're going to have to prove that you disclose everything. And same for the other party. If you challenge it, the other party's going to have to prove that they disclosed everything. And if you hid $1 million bank account from before you execute the prenup agreement, well, guess what? The prenup might be thrown out or partially thrown out. One other thing, and then I'll throw it back to Matt. If you can kind of connect some dots here, what that would mean is that your divorce is probably going to be prolonged because you're dealing with a prenup and whether or not it's valid. And in Florida, we can bifurcate that, meaning the court makes a determination at the beginning whether or not the prenup is valid, because if it is valid, then it's going to expedite the divorce. If it's not valid, then you're going to be back at square one, plus the time it took to determine whether or not that prenup is valid. So just make sure you do it in good faith and you comply with everything you need to comply with. You keep it narrow. And if you have tons of assets and tons of property and brokerage accounts and everything, that's fine. I'm not saying that it only has to be one or two things, but you just want to make sure that they're specifically identifiable.
And the other way that it starts to get messy is prenups become more and more unfair over time. They can seem fair at the beginning, at the outset of the marriage, but 15 years later, 20 years later, they could seem very, very unfair. And a perfect example, let's take Brian's example, where the soon-to-be husband owns 2 investment properties, LLCs, that he's owned for 5 years prior to the marriage. He bought them using his own money, working, saving up money after college, buys these 2 investment properties. Then he's looking to get married, and he just wants to say, look, out of an abundance of caution, just want to get a little prenup done, protect these 2 properties so that not only are the 2 properties and 2 LLCs going to never be considered marital, which, I mean, they're premarital to begin with, so the default rule is that they wouldn't be, but just to make sure that the spouse doesn't have any claims whatsoever to any appreciation of value or anything like that from these properties, let's get that prenup done. But that prenup is also going to say that any proceeds from the rental income, proceeds from the sale of the homes, and then even additional investments made from the sales of those proceeds are all going to be considered non-marital. Well, then guess what's going to happen? The soon-to-be wife signs that prenup. Everything's good for like 5 years. He's renting out the 2 properties. He's probably barely making a profit on them because they're mortgaged. But any profit that he does make, he kind of just reinvests into those properties. But after 5 years, now he's sitting on, $400,000 of equity because the market's gone up. And he sells those 2 properties and makes $400,000, invests it in the stock market. And since they're proceeds from the sale, they're covered under the prenup, any money that he makes on the investments is also going to be outside of the marriage. And now he's day trading in those accounts on a daily basis. So instead of focusing on increasing the marital net worth, he's really only focused on increasing the premarital net worth. So after 15 years, now he's got $1.5 million in there. He's never put any money into his 401k from his work. He's never actually contributed towards increasing the value of the other marital resources. And now he can go get divorced, walk away with his $1.5 million, and there not be any other marital value that's been created because he's been focusing all of his efforts on the non-marital value. So that's where a prenup can become unfair over time. Another thing is there's some psychology to prenups. They're not just some paperwork that you get done before a marriage. You got full financial disclosure. They got to be negotiated out. If you really want them to hold up in court, each party should have a lawyer, and the terms should be negotiated between the 2 lawyers and 2 parties. A lot of times these prenup negotiations are kind of like a divorce negotiation. So you're kind of pre-negotiating a divorce before getting married is essentially what it is. And then what it also does is it creates a power imbalance in the marriage. You're basically codifying on paper, I'm wealthier than you. I can survive without you. I don't need to split up these things if we divorce. You need me more than I need you. That's what it does. So it creates a power imbalance from the beginning. Now, that's why I said, if you're both older people and you both have already built your wealth, you've already raised your kids, you've been divorced a time or two, and you're each sitting on roughly $2 million of assets, and you want to get a prenup, there's not going to be that power imbalance. Your family's already been built. You've already raised your kids. Your nest egg is already built. You're not trying to build the nest egg. So in that sense, a prenup might be perfectly fine. But for younger couples starting out, even if one person has a lot more assets early on in life than the other, it can kind of create more problems in the relationship that it solves. Just ask yourself realistically, how many young people that are wanting to start a family, get married, are in love with each other and then want to negotiate a prenup? That's probably not a very fairy tale situation. There's got to be something in it for the person that wants to get the prenup negotiated. If I had a daughter, I use this example, I would not want her to sign a prenup when she gets married. I think it takes away a lot of the benefits to marriage. And likewise, I have a son. Even if my son is independently wealthy or something like that, I want him to enjoy an actual relationship and marriage. I'm not going to push my son to sign a prenup, so to speak. So it certainly works for some people, but in my opinion, I think there's a lot of important drawbacks to it, and it actually will get you into more trouble than it'll save you.
Yeah. And I mean, those are personal opinions, and Matt and I are human beings, so we have our personal opinions. Going back to objective speaking for a minute here, um, here's a little general rule if you're considering getting a prenup. If you think you're going to draft it yourself and it's going to be valid, look, is it possible? Yeah, I guess. I mean, it could be. But, you know, that's probably a little bit of an uphill battle. So then the next question is, should I get a lawyer? Yeah, you absolutely should get a lawyer if you want to get a prenup. I can't afford a lawyer. Well, then you probably don't need a prenup. If you do end up drafting a prenup, it needs to be legally sufficient or else it's just going to be worthless. For instance, you're not going to put in the prenup that nobody pays child support. Guess what? If you have children, there's going to be a child support determination. And maybe that determination is zero, but nonetheless, there still has to be a child support determination. Matt's point is very well taken that the longer that you're married, the more that you might end up kind of scratching your head when you're looking at a prenup as the judge. And so there's some provisions in there that we've seen them before where at 10 years of marriage, this occurs, or at 15 years of marriage, this occurs. But there's also things that you probably wouldn't think of as a layperson or non-attorney who doesn't deal in this world. What happens when you have a property that's subject to a prenup? Let's just say like a completely rock solid prenup, and you sell it, and then you take the $100,000 of proceeds and you put it towards the mortgage, right, to your marital residence that isn't subject to the prenup. And then 6 months later, your spouse comes to you and says, "I want to get a divorce." Did you lose that $100,000? I mean, probably it commingled funds that shifted from a prenup to non-prenup. But on the flip side, these are things where if you really take the time and pay an experienced attorney to draft it, they might say, okay, well, why don't we put a provision in there that says X, Y, and Z? Another aspect for a prenup would be if you and your spouse are getting married and your spouse doesn't have any money to contribute for a down payment, and you have 250,000 and you're just like, man, this just is a lot of money, and just in case the marriage goes south and we end up in divorce, I don't want to be out that money. That might be something that could be reduced to a somewhat reasonable prenup where, hey, in the event of a divorce being filed within 5 years of the date of the marriage, spouse A, husband, wife, whatever, doesn't matter, the wife is entitled to the first $250,000 from the sale of the marital home. But then this is where it starts to get complicated. What happens if you sell that home and buy a new home? And then the new home isn't specifically listed in the prenup. All these things can be accounted for. All right. But, I say it to say that you're going to want an attorney who drafts contracts to draft the contract, because that's what a prenup is. And it's interpreted under contract rules in the state of Florida. If you've ever been in a situation where you're dealing with an attorney with contracts, a lot of times contracts are just held up and they're valid. Other times there's horror stories out there. I think a couple of years ago, there was one that was circulating about the use of an Oxford comma and whether or not this $5 million contract was valid or not. I think the Supreme Court said, no, there's an ambiguity in the drafting of it because there was the use of an Oxford comma. So therefore we're not sure. And we're throwing out the contracts. Contracts get thrown out all the time. They also get enforced all the time. So I think the more specifically tailored and narrow you can make the prenup with identifying specific assets, by account numbers, legal descriptions, if it's real property or if it's a trust, it's going to be better.
And going on, not all prenups are enforced. You can have a prenup done for one reason or another. The judge might not choose to enforce it. But here's a good scenario. Let's say you're getting married, you're a man, you've got some assets that you want to protect, you've been engaged for a year, and your soon to be wife's family is paying for the wedding. And they've booked the venue, they've bought the dress, they bought the cake. Her parents are out like $60,000, $80,000 on a wedding. Money's already been spent. People have already bought plane tickets. You're getting married in 2 weeks. And then you present your soon to be wife with a prenup, and tell her that she has to sign it or else you're not getting married. Well, now she feels like she's obligated to sign it because she doesn't want to go back to her parents and tell her parents that they're going to lose $60,000 to $80,000 and suffer community embarrassment by backing out of it and refusing to sign it. So what does she do? She signs it under essentially duress. And 10 years later, either of you file for divorce, doesn't matter, it could be you, it could be her. And when you present that prenup and she tells that story, there's a very good chance the judge is going to determine that that prenup is not going to be enforceable. Even though she was a grown woman capable of reading it, understanding what she was doing, under those circumstances, that might not be an enforceable prenup. So for anybody that is considering doing a prenup, the most important thing is to get the negotiation process started well before any commitments have been made to get married, before money has been spent on venues, even before people's parents are told. You don't necessarily want to get your close network of friends and family all hyped up over a wedding and then start negotiating your prenup. So those things need to be negotiated well in advance. Both people should have lawyers. Both people should do financial disclosure, and there needs to be a due diligence period. There should be some kind of back and forth on the terms in the prenup, and it should be made on a level playing field. And if the two people can't agree on the terms of the prenup, then they obviously should not get married. But if you're somebody who is pursuing a prenup, springing a prenup on somebody last minute prior to a wedding after commitments have been made, not a good idea for your relationship, not a good idea legally if you actually want to get it enforced in the future.
To tag along with that, I think that holistically, think about it this way. You're not just going to show up after a day's work to your fiance and say, here's a document, review it and sign it. They're going to look over it and say, does this mean anything? Should I be worried? And you go, no, it's good. It's good. And then they sign it. And if that's how you're envisioning a prenup working, it's not going to hold up because that's just not how the process works. If you get into the mentality of having a clear conversation with your spouse, hey, these are the 6 assets that if we do get divorced, hopefully we never do, but I want to retain ownership of them, completely separate outside of the marriage, and I would like to reduce that to writing. Are you willing to work with me on getting a prenup drafted? And the spouse is like, yeah, no, completely understand. That's completely fair. If we ever did get divorced, I don't want your rental property. That's yours. I understand you worked hard for it. And you go, okay, cool. And you go hire John Q. Esquire to draft up the prenup. It's a process, whether it takes a week or a month or however long it takes. And there's some back and forth and you're meeting and everything's all good and dandy and everybody's disclosing everything. That's kind of the process for a prenup that you're going to want in order for the prenup to be valid. But slapping it on the table at the 11th hour right before marriage or something, just not a great way. Maybe it holds up in court, but you're probably a little bit of an uphill battle on that one.
Yeah. If you're looking to protect something of value, it's worth trying to do the process correctly to make sure that it's actually going to be protected so that you can sleep well during the marriage, or God forbid, if you were to go get a divorce, you want to know that you did everything right. You cross the T's, dot the I's, and you know that it's going to hold up. Listen, we're litigators. And what we do on a daily basis is we litigate cases. We argue these prenups. We have cases that involve prenups. We argue why they should be enforced. We argue why they should be tossed out. We do it on both sides, so we know the arguments. And all we need as litigators is just to crack the door a little bit. We don't even need to completely prove that the prenup should be thrown out. We just need a couple seeds of doubt that it might not be enforceable. And with that leverage, we can get our clients a really good deal or a better deal than they would have gotten under the prenup just by being able to poke a few holes in the armor of whether or not the prenup is going to be enforceable. Likewise, when we're on the other side of it, what we're doing is we're running defense. We're trying to prevent the other side from poking any holes in the enforceability of it. So it goes both ways, but that's why you want a prenup done correctly, and not just drafted correctly, but the disclosure, the timing, doing it without duress, doing it before commitments have been made on the wedding. Those are the things you want to do. You want to do it well in advance of getting married. You want both people to cooperate in the process. You want both people to have lawyers. assuming everything gets done well and correctly, prenups in Florida are enforceable. That's a general rule. And there's a lot that you can negotiate prior to a marriage to try and make the divorce easier, quicker, or more fair to you if you're the one entering into the marriage with assets. But they're not going to cure every problem. And one last thing I'll say is Florida already has default rules regarding how property gets distributed in marriages. Florida already has rules about how non-marital property is different than marital property. Florida already has rules that protects inheritances in a divorce. Florida has rules that determine what portions of financial investments are marital versus non-marital and who gets what. So you basically already have a default prenup. Everybody does when you get married. So when you're actually negotiating a separate prenup, what you're doing is you're trying to create more rights for yourself and less rights for the other person than what Florida law's default rights are. So with that, there you go. So that's prenups in a nutshell. If anybody has questions about their prenup, they're in a marriage, there was a prenup, they're thinking about getting divorced, they want to know if the prenup's going to be enforceable, or if they're on the other side, what they can do to try to fight against the prenup, or just to understand what their rights are if they were to get divorced with their prenup, you can give us a call. We do 15-minute free consults. It's easy to book. You can call our phone number, visit our website, schedule a consultation. You talk to Brian or I, and we can kind of fill you in on and give you some more fact-specific advice. Again, this is Matthew Waring, and I'm here with my partner, Brian Dunmire. This has been another episode of Divorce Well in Florida, brought to you by Fairway Law Group. And we'd appreciate it if you liked and subscribed to the podcast so you get notified when a new one comes out. We do one every week, and we will see you soon.